Hi everyone, my name's Daniel Rosen and I'm an entertainment lawyer that specializes in corporate and commercial matters in the music, film, TV, and digital media industries. Currently, I'm the head of business and legal affairs at Monstercat, which is North America's largest independent electronic music record label based in Vancouver, BC. I've been working in the music industry for over a decade in various capacities, including artist management, music licensing, producing, DJing, and engineering. And as a lawyer, I've advised on deals with some of the world's biggest artists and companies. Today, I'm here to share my knowledge with you about music law and copyright. Thank you for joining my Jumpstart Foundations class. Now let's get started. In today's lesson, we'll be covering music law, including an introduction to copyright law, how copyright applies to music, how music royalties work, an overview of the common music contracts you may see, and how to best protect yourself when creating and releasing music. Now, disclaimer before we get started. I'm not here to provide you with legal advice or to be a substitute for any lawyer. I'm here to give you tools that will help you better understand music law and copyright, music royalties, and music contracts. Additionally, the subject matter of this lesson is limited to Canada. There are many similarities in copyright laws around the world. However, there are some differences which I do not go over in this lesson. By the end of this video, you will be able to understand the fundamentals of music law and copyright. And by understanding these fundamentals, it will allow you to better apply these concepts to your creative or professional endeavors. So get ready and let's begin. Part 1, Copyright Law Basics. In Canada, copyright is defined as an exclusive legal right under the law, which gives a person the exclusive right to produce, reproduce, sell, license, publish, or perform a work or any substantial part of it. This exclusive legal right gives creators, like musicians, a financial incentive to create music and other types of art, since there are revenue streams derived from these rights. And creators know that there are rules in place to prevent others from doing things that are contrary to this exclusive property right without compensation. Holding a copyright can be a valuable business asset, and many musicians and music industry professionals are able to make a good living off of royalties derived from copyrights. But what exactly does copyright protect? Let's get more specific. Copyright law protects what are called works and other subject matter. In Canada, there are 4 types of works: artistic works, dramatic works, literary works, and musical works. And the music industry generally centers around the exploitation of musical works, which are also called songs or compositions. Additionally, Canadian copyright protects 3 types of other subject matter: sound recordings, performers' performances, and communication signals. Those tracks you listen to on Spotify or Apple Music are sound recordings of musical works, also sometimes called master recordings or just masters. And the performances on those sound recordings are called performers' performances. Now, each of these has a bundle of exclusive rights under copyright law attached to it. As the owner of a work, you have the exclusive right to produce or reproduce the work or any substantial part of it in any material form. This includes making copies of it. You also have the right to perform the work or any substantial part of it, such as playing the work at a live concert, and you have the right, if the work is unpublished, to publish the work or any substantial part of it, which includes making copies of it available to the public. In addition, there are a number of additional rights you get as an owner of a work. These include the right to translate it, communicate it to the public by telecommunication, like on radio or television, to create a sound recording which contains the work, and even to create a movie or a novel based on the work. These rights are referred to as owner's rights in relation to a work. For sound recordings and performers' performances, we see something very similar. The owner of a sound recording has the exclusive right to publish it for the first time and to reproduce it. And the owner of a performer's performance has many exclusive rights, including the right to fix it in any material form and to reproduce any sound recording of it. In addition, owners of sound recordings and performers' performances have what is referred to as equitable remuneration rights, which allow the owners of those copyrights to make money for the public performance and communication to the public by telecommunication of their sound recording or performer's performance. Now, you may have noticed I've been using the word owner and not author. This is a very important distinction under copyright law because sometimes the author of a work is not the owner of that work. This is often the case in music, such as when a songwriter has assigned their copyrights to a music publisher. Let's look into this further. Who is the owner of the copyright? The Copyright Act has a general rule to determine ownership of a work, which is that the author of the work is the first owner of that work. Section 13 of the Canadian Copyright Act reads, "Subject to this act, the author of the work shall be the first owner of the copyright therein." The inclusion of "subject to this act" is very important. This is because there are some exceptions to this rule. The author of the work is not always the first owner. A common exception under Canadian copyright law is a work made in the course of employment. In these cases, the employer of an employee owns the copyright in a work made during their employment. So, if you're a songwriter employed by someone to write songs, your employer automatically owns these under the Copyright Act unless you have contracted otherwise. Despite these statutory rules, the Copyright Act provides us with lots of flexibility in contracting to assign or license our copyrights. Section 13 of the Copyright Act provides a broad right for an owner to assign and license a copyright. Let's read through it together. The section reads, "The owner of the copyright in any work may assign the right, either wholly or partially, and either generally or subject to limitations relating to territory, medium, or sector of the market, or other limitations relating to the scope of the assignment, and either for the whole term of the copyright or for any other part thereof, and may grant any interest in the right by license. But no assignment or grant is valid unless it is in writing, signed by the owner of the right, in respect of which the assignment or grant is made, or by the owner's duly authorized agent." If you analyze the language in this section, you'll realize that there is a lot of flexibility that an owner of a work has. They can assign and license only parts of their copyright. Assignments and licenses can be specific to certain territories in the world and for specific time periods. The possibilities are really endless. But just remember, no assignment or license of copyrights is valid unless it is in writing and signed. The general rules for works also apply to other subject matter under the Copyright Act. However, instead of author, we call the first owner of a sound recording the maker, and for a performer's performance, it is the performer. And similar to works, the Copyright Act provides the same broad ability for owners of sound recordings and performers' performances to assign and license their copyrights. Let's switch gears and talk about moral rights, which are an important part of copyright law in Canada. Moral rights are different from owner's rights. They are the right of the author of a work or the performer of a performer's performance. So to be clear, there are no moral rights in sound recordings. There are three types of moral rights. The right of paternity, which is the author's right to have their name on a work, to use a pseudonym, and to remain anonymous. The right of integrity, which is the right of the author to object to any changes of their work that may harm their reputation as an author. And the right of association, which gives an author the right to prevent anyone else from using their work in association with a product, service, cause, or institution. Now, unlike owner's rights, which can be assigned and licensed via contract, as we discussed previously, moral rights cannot be assigned. However, moral rights can be waived. And if you waive your moral rights under a contract, then you cannot exercise them against the other party to that contract. So now we understand owner's rights and moral rights, but we need to discuss a very important aspect of copyright law. When exactly does copyright arise in a song, recording, or performance? For copyright to arise and to have copyright protection, there is no need to register your copyright. This is because copyright arises upon fixation. Fixation has to be in some tangible form. This includes writing or recording. So, for example, once you take out your phone and record the song you wrote, your musical work is fully protected by copyright law. Isn't that easy? In order for something to be copyrightable, there has to be what is called original expression. It is important to note that you cannot copyright an idea. Ideas themselves are not copyrightable, but expressions of those ideas are. So for example, a single chord pattern would be classified as an idea under copyright law. It's a set of chords that has been used over and over again. Certain chord patterns have been used in hundreds of songs and form building blocks of those songs. But there is a certain point where an idea becomes an expression of an idea, where there is sufficient original expression. So when you take the chords, arrange them into a song and write lyrics, you have created now what is a copyrightable musical work. There is a threshold where an idea turns into original expression, and that's pretty low. The author just needs to exercise some skill and judgment. This concept becomes especially important when it comes to creating with others. We all know it's very common to collaborate with others on songs and records. From a legal perspective, we call this joint authorship. Now, a work of joint authorship is defined as a work that's produced by the collaboration of two or more authors in which the contribution of one author is not distinct from the contribution of the other author or authors. So even though sometimes John Lennon would write the melody and Paul McCartney would write the chords for Beatles songs, their efforts fuse together into a single unified whole. For a work to be jointly authored, each author has to make a significant contribution to the work, and they have to intend that their contributions are to be merged into a single unified work. The easiest way to clarify joint authorship is to have a simple written agreement between the parties, which doesn't have to be complicated. Even a simple email chain can work. And if you clearly outline what the ownership percentages of a work are before you start creating it with someone else, then that will eliminate confusion and any arguing in the future, which we know is no fun. Once we know who the owner of the work or other subject matter is, how long will they hold their exclusive rights for? In Canada, for works, duration of copyright is the life of the author plus 50 years. And this will soon be changed to 70 years. And in the cases of jointly authored works, the duration of copyright in a work is the life of the last surviving author plus 50 years. So, even after the authors of a work die, their estates can reap the economic rights attached to the copyrights. For sound recordings, the owner's copyright expires 70 years from the end of the year which the fixation of sounds on the record occurs. And for performers' performances, it is 50 years from the end of the year in which the performance occurs. Once the copyright protection period ends, the work or other subject matter enters what is called the public domain, meaning anyone can use it without any obligations, financial or otherwise, to the owner or author. However, even if something has entered the public domain in Canada, it may not have in another country with a different, longer copyright protection period. During the copyright protection period, in addition to owners and moral rights, copyright users possess limited rights under the law to use copyrighted works and other subject matter. The government has determined these limited exceptions to copyright protection are important for our society. There are some instances where it's important for us to be able to use copyrighted material of others without worrying about infringement or paying for it. The most prevalent user's right in Canada is called fair dealing. Under this right, you're allowed to use another person's copyrighted work or other subject matter for the purposes of research, private study, education, parody, satire, criticism, review, and news reporting. Some other examples of users' rights include the right to make copies for private use and the ability to create non-commercial user-generated content. The key takeaway here is to understand that you don't always need to pay or ask permission to use the copyright of others. Now that you have a basic understanding of copyright law, let's dive into how music copyright and royalties work. Recall in music, we are generally dealing with one type of work, the musical work, and two types of other subject matter, sound recordings and performers' performances. Let's dive into these a little deeper. Musical works consist of melody, harmony, rhythm, and lyrics. The representation of a musical work is what you can write down on paper as sheet music. And as stated before, the musical work copyright is different from the sound recording and performance of that musical work. Sound recordings are recordings. They can be of musical works, other types of works, or just sounds. Artists create sound recordings of songs they have written and songs that are written by others, also called covers. For example, the original recording of the song Let It Be was by the Beatles, but since then there have been a number of cover recordings of the song by other people. Finally, a performer who performs on a sound recording owns the copyright in their performer's performance on that recording. With a firm grasp on these three copyrights, we can now dive into music royalties, which are derived from the exploitation of these copyrights. For musical works, sound recordings, and performers' performances, there are a number of different types of royalties that can be derived. For musical works, there are three major sources of royalties: public performance and communication to the public by telecommunication royalties, mechanical royalties, and synchronization licensing royalties. Public performance and communication to the public by telecommunication royalties are collected and distributed by the collective management organization SOCAN in Canada, and are earned when a band plays a song at a live show, or when a song is played in a radio or TV broadcast, a streaming playlist at a bar, or any other type of public performance or broadcast, even on YouTube. Mechanical royalties are collected and distributed by the collective management organizations, the CMRRA and SOCAN, when CDs or digital downloads are sold, or when a song is streamed on a digital music service. Synchronization licensing royalties are royalties that are earned when a song is included in an audio-visual production, like a film, TV show, or a video game. These rights are contracted for privately. For sound recordings, there are also three major sources of royalties: sales and streaming royalties, public performance and communication to the public by telecommunication royalties, and synchronization royalties. Sales and streaming royalties are collected by record labels or by artists if they self-release. These are earned when a sound recording is sold or when it is streamed on a digital music streaming service. Public performance and communication to the public by telecommunication royalties for sound recordings are often referred to as neighboring rights royalties. These are collected and distributed by the collective management organization Resound and its affiliates Connect Music Licensing and SoProc. Like musical works, these royalties are collected when a sound recording is played in public or on a broadcast. Synchronization licensing royalties are, like those for musical works, earned when a recording is included in a TV show, film, video game, or other audiovisual production. For performers' performances, there are two major sources of royalties: royalties derived from the inclusion of a performance on a sound recording, and public performance and communication to the public by telecommunication royalties. Fees and royalties that a performer receives for their performance on a recording are often handled in side performer agreements, which will be discussed shortly. Performers also make public performance and communication to the public by telecommunication royalties, much like musical works and sound recordings. In Canada, performers can collect these through the collective management organization Resound or its affiliates Actor Rax, Artisti, and MRock. Now, just a quick note here. If you're a songwriter, artist, producer, performer, label, or publisher, ensuring you are registered with the right collective management organizations is vital to earning the royalties you are entitled to. Once you understand basic copyright law, music royalties, and how to earn and collect music royalties, it is then easier to get a grasp on the common agreements that exist in the music industry. Part 3. Music contracts. The music industry is full of collaboration, both during the writing process and during the music exploitation process. And that helps music industry professionals thrive, being the best at their craft while working with others to assist with the other stuff. In this section of the lesson, we'll talk about three major types of agreements you may encounter in the music industry: agreements involved in the music creation process, agreements that deal with exploiting your music, and general professional agreements. When creating music, there are important things that should be agreed upon and rights that are assigned or licensed before a recording is commercially released. This will allow you to release music without headaches down the road. The most common types of agreements you see in the music creation process are songwriter split agreements, side performer agreements, and producer agreements. I'll go over each one in turn. Songwriter split agreements are usually simple, as their main purpose is to lay out what the ownership percentages of a song are. Usually there is no licensing or assignment of copyright in the musical work. It's mainly just a split sheet detailing the percentages. However, there are some types of these agreements that grant additional rights to some or all of the writers, or even further to labels or publishers. When entering into a song split agreement, keep an eye out for additional rights you may be granting. A standard right to grant is a first-use mechanical license, which allows an artist or label to release the first recording of the song. Make sure you read through the entire agreement and ask questions about any sections or wording you don't understand. Side performer agreements are very common for any vocalists or musicians hired to perform on a recording, ensuring all necessary rights are cleared. In exchange for a grant of rights, the performer will receive compensation, either a flat fee, a percentage of royalties, or a combination of the two. As a performer, make sure you look at when you will get paid your fee. Performers should ensure they understand how royalties are being calculated, ensuring they are receiving the royalties directly from the label if there is one, not from the artist, and on at least the same terms as the artist. And if credit was agreed upon, it should be included too. It's completely normal for performers to waive their moral rights in their performance. However, as a performer, it could make sense to ask for language in the agreement preventing the performance on the recording from being materially or fundamentally altered without their permission. While these agreements take many shapes and sizes, each party should ensure that the agreement says what the party intended it to. A producer agreement will set out how many master recordings will be produced by the producer and what the compensation for the production services will be, either a flat fee, royalties, or both. Royalty provisions in these agreements can be complicated and are a little advanced for us to dive into here. However, it's important for the producer to be paid directly by the label if there is one. And a producer will always try to be paid on gross royalties as opposed to net royalties, which is disadvantageous to the artist. For flat fees, producers will always want to get paid as much as possible up front, and for the fees to be non-recoupable and not advances against their royalties. This is because if the fee is an advance against royalties, the producer's royalties earned from the recordings would have to at least equal the fee paid before they start seeing additional money. Like side performer agreements, it is standard for the producer to assign all of their rights in the master recordings to the artist or band, or the label if the artist or band is signed. Moral rights do not exist in sound recordings, so there's no need for a waiver of moral rights in a producer agreement, unless the producer is performing on the record. And, like side artist agreements, make sure that the producer credit is specified. It's not uncommon for a producer agreement to also give percentage of ownership to the songs being recorded to the producer. If the producer is being granted a songwriting royalty, make sure that it is warranted and that it does not come with other rights. As an artist, if you see other provisions such as the sunset clause giving the producer the first right to produce the next album, or rights to royalties on future albums even if they don't produce them, I would ask for them to be deleted unless the circumstances warrant them to be staying in the agreement. Negotiating producer agreements is highly specialized and usually requires legal expertise. As an artist, label, or producer, ensure you understand the main financial terms of the contract before engaging a lawyer. The reason that music publishers and record labels exist is because they have the expertise and experience in successfully exploiting the musical work and sound recording copyrights. In my experience, as an artist or songwriter, licensing or assigning your copyrights to a label or a publisher is often a great idea. A record label can take your release to the next level using their marketing and industry expertise, and a music publisher can effectively and efficiently monetize your song by providing support in song registration and licensing. It's important to be careful when entering into agreements with labels and publishers. Often deals presented by these parties are not friendly to artists and writers, are long, confusing, and contain many provisions that can ultimately be negative for a writer or artist. There are many forms of recording contracts. These range from a single master contract in which only one master is licensed or assigned to the label, to multi-album exclusive deals, and everything in between. There's even what is called a 360 deal, where a label also takes part in an artist's other entertainment industry revenues, such as from touring and personal appearances. Now, regardless of the type of deal, each record deal has a basic structure. The artist will either license or assign the copyright in one or more sound recordings to the label, along with providing them the right to retain a royalty, and in return, the label will use its marketing power and expertise to exploit the sound recording copyrights. Understanding the royalty provisions of these contracts is important because it is how artists are paid. So make sure the label cannot deduct unreasonable expenses and charge it to the artist's royalty account. Advances are common in record contracts, and these are a flat fee that is paid to the artist that gets applied against the artist's royalties. Royalties will not be earned until that advance is recouped, meaning that your portion of the royalty has to equal the advance. Ensure you understand how long the license or assignment term is. Is it forever? 10 years? For artists, the shorter the better. And is it worldwide or country specific? With respect to getting paid, most record labels don't pay that often. Most labels pay twice a year, sometimes quarterly if you're lucky. If you're relying on record royalties to live, keep the timing of payment in mind. If the masters are not completed, look for any approval rights in creative control. And how does the approval process work? If marketing commitment is important to the artist, it may be helpful to ensure the label contractually commits to spending a certain amount of money marketing the record. A firm commitment to market may prevent a label from signing the record, releasing it, and doing nothing to promote it. There are a number of other common provisions which we don't have time to go over in this lesson. My advice is that if you're entering into a record deal, consult a lawyer to assist you in negotiating it. There are a number of small entertainment law firms in Canada who can offer cost-effective solutions to help you. Similar to a recording contract, except with the musical work copyrights, a music publishing contract is when a writer assigns or licenses the copyright in one or more musical works to a publisher, in exchange for the publisher retaining a percentage of the royalty derived from the work or works, and for exploiting the copyright. These contracts can be for single songs, a writer's past catalog of works, and for future songs written, or a combination of these. For future songs written, the deals are usually exclusive, meaning that all of the writer's songs for a certain period are assigned or licensed to the publisher. A standard music publishing split is 50-50 between the publisher and writer. Commonly, the 50% retained by the publisher is called the publisher's share, and the 50% retained by the writer is called the writer's share. The writer will get paid their public performance and communication to the public by telecommunication royalties in Canada via SOCAN directly, and all other royalties will be paid by the publisher. The standard splits for co-publishing agreements are generally 75-25 in favor of the writer. Administration agreements range even lower and could even be below 10% for the publisher. These splits are generalizations, however, and royalties are often broken down further into specific sources, such as mechanical royalties and synchronization royalties, which may have different rates. Like record contracts, timing of payment is important. Most publishers will pay quarterly. Also, ensure you understand how the advance works. Make sure you look at how long the license or assignment is for the compositions under the deal. Is it forever or for a time-limited period? If it's time-limited, what happens when the rights revert? There are also many other provisions that we don't have time to dive into here, and these agreements are highly specialized, usually requiring legal expertise to negotiate. In addition to agreements that deal with copyrights, there are other common types of agreements we see in the music industry. These types of agreements often have to do with setting up your team. An artist manager can play a key role in an artist's career, assisting them in getting their deals with labels, publishers, endorsements, and so much more. Under a management contract, a manager agrees to perform services to further the career of the artist in exchange for a certain percentage of the money earned by the artist. The manager is incentivized because if the artist is not earning money, then the manager will not be either. The normal compensation for managers is 15 to 20% of the money earned by the artist. This calculation often is made before the artist has to pay certain expenses, making it a gross receipts calculation. What is not included in gross receipts is often negotiated in these contracts. This is where a lawyer specializing in these types of agreements can help. The term of a management agreement can be short or long, and often there are options to extend, either at the option of the manager, artist, or upon mutual agreement. As a general rule, before entering into a long-term contract with anyone, make sure that they are a person or company you are confident you want to work with. It's common for management agreements to contain a sunset clause, allowing a manager to continue to make commissions after the contract term ends. The reason behind a provision like this is because a manager will put a lot of effort into a career of the artist, and if the artist and manager part ways, the manager should reap the rewards of their efforts during the term. The commissions are often reduced on a year-to-year basis during the sunset period. If you are an artist, try to make the sunset clause as short and the commission as low as possible. Management contracts generally give the authority for the manager to act on behalf of the artist, including entering into contracts for them and using their name and likeness to secure deals and endorsements. As an artist, you don't want the manager coming and asking you every single time they're entering into a deal, which can slow things down, but you want to have some approval rights, especially on bigger and more important contracts. All in all, making sure that both parties are happy with the final agreement is critical in fostering a healthy, long-term professional relationship. With a properly and fairly negotiated agreement, the artist and manager relationship can be a great one for many years. Band agreements make all band decisions much easier, setting up a framework for members to work within, including when conflicts arise. Band agreements can detail how royalties work, how profits and losses work, how song and record ownership is allocated, and how decision-making and voting works. In addition, a band agreement can provide the right to kick out a band member for bad behavior. These agreements cover many things, like whether a band member can perform musical activities outside of a band, or what happens when the band dissolves, or even what happens when a band member leaves the band. Again, having a lawyer to help draft and negotiate these agreements is always recommended. The best practice is to make sure that each member has their own representation, so their interests are fully represented. To sum everything up, in today's lesson we went over the basics of copyright law, how copyright law applies to music, how music royalties work, and did a high-level overview of some common agreements you will see in the music creation and exploitation process. The music industry is founded on the exploitation of the musical work, sound recording, and performer's performance copyrights. And artists, producers, musicians, labels, publishers, managers, and other music industry professionals can make a living off of the effective exploitation of these copyrights. Having a basic understanding of copyright law and how to properly ensure you, companies, and people you work with are protected when creating and releasing music is something every music industry professional should be equipped with. So I hope that you can take the information and understanding you've acquired from this lesson and use it to help creatives and other music industry professionals monetize copyrights and earn a living in the music industry. I'm Daniel Rosen, and thanks for attending my Jumpstart Foundations Masterclass.